Good afternoon, everyone. Welcome to today's webinar, Delaware Disrupted: The Battle of Corporate America, sponsored by the Loin Economic Center's program on financial markets and the Civil Justice Academy at George Mason University's Anthony Scalia Law School. I'm Paolo Saguato, and I'm a professor at Scalia Law School, and I'm the founder and director of the program of financial market, and I'll be moderating today's discussion. The webinar is designed around the mission of the Loin Economic Center to serve as a nexus for academic research and education that focuses on timely and relevant economic analysis of legal and public policy issue confronted judges, lawyers, and policymakers nationwide. We thank you all for joining us today to be part of that ongoing dialogue. Our panel of experts today each come to the discussion with impressive backgrounds, researching, teaching, and analyzing the development of corporate law and governance. So that we can reserve time for substantive discussion, I will give only a very basic introduction rather than extensive bios of our speakers. To learn more about each panelist, I recommend that you click on their names in the invitation you receive from the LSE to join the webinar or to visit the LSE website. The panelists, in order of their presentation, are Sean MacDonald, is Associate at Hogan, Lovells, and former clerk for Chancellor McCormick of the Delaware Court of Chancery. Kyle Lachmund is Director at Richard, Layton, and Finger, and a former clerk for Vice Chancellor Travis Laster in the Delaware Court of Chancery. And Lipton is the Michal Fleishman Professor in Business Law and Entrepreneurship at Tulane University School of Law. Michal Barzuza is Professor of Law and Director of the John Glynn Jr. Law and Business Program at the University of Virginia School of Law. If you have any question, please submit them using the Q&A box at the bottom of your screen. Please identify yourself in the text of your message and keep your questions short so that they can be readily incorporated into this virtual format. So without further ado, Sean, the floor is yours.
Great. Thank you, Paolo. Give me a moment to share my screen here. Is that what it's supposed to be? Yeah, that looks right. Okay. Good afternoon, everyone. First of all, I'd be remiss if I didn't mention that I became a dad 1 year ago today, so happy first birthday to my son. I hope he's listening carefully and taking good notes. My job today is to attempt to summarize the many and significant changes to Delaware corporate law introduced by Senate Bill 21 in 10 minutes. Wish me luck, and please keep in mind that this is a summary, and unfortunately a certain level of imprecision is required to keep this short and sweet. At a very high level, SB 21 altered two statutes. First, it amended Section 144 of the Delaware General Corporation Law, or DGCL, with respect to conflicted transactions, in which directors, officers, and/or controlling stockholders of a given corporation stand on both sides. Second, it amended Section 220 of the DGCL, which grants stockholders the right to inspect the books and records of corporations in which they hold equity. Beginning with conflicted transactions, the first three subsections of the new Section 144 establish safe harbors for directors, officers, and controlling stockholders that participate in conflicted transactions. If the conditions to invoke these safe harbors are met, such conflicted transactions may not be the subject of equitable relief or give rise to an award of damages against such conflicted persons. This language in particular, along with some other language in SB 21, has prompted at least 6 constitutional challenges in the Delaware Court of Chancery since SB 21's passage, based on alleged infringement of the court's equitable jurisdiction. Before SB 21, interested director or officer transactions were subject to entire fairness review, the most stringent standard of review in Delaware, under which the defendant would have to prove that a conflicted transaction was entirely fair as to both process and price. But there were 2 ways to avoid entire fairness review and cleanse a transaction such that it would receive the benefit of the deferential business judgment rule. First, a special committee comprising fully independent directors with the ability to negotiate the transaction, consider alternatives, and say no, could approve the transaction if the committee was constituted and authorized before the start of substantive economic negotiations. Alternatively, a majority of disinterested, uncoerced, and fully informed stockholders could also approve the transaction before its execution under a 2015 Delaware Supreme Court decision called Corwin. SB 21 imported these cleansing mechanisms into Section 144 in significantly altered forms as 2 safe harbors. Under the new Section 144, there is a safe harbor for transactions in which a majority of the board's disinterested directors are aware of the material facts of the conflict and nonetheless vote to approve it in good faith and without gross negligence. If a majority of the board is not disinterested, a committee of 2 directors, which are determined to be disinterested by the board, can invoke the safe harbor by approving the transaction with no requirement that the committee can negotiate it or reconstitute it before negotiations begin. The stockholder safe harbor, on the other hand, now permits a majority of disinterested stockholders to ratify conflicted transactions after the fact, which was not a feature of the pre-SB 21 stockholder vote cleansing mechanism. Everything I've discussed so far has been about conflicted directors and officers, but the heart of the SB 21 controversy lies with controlling stockholders. This issue traces in part back to the 2014 Delaware Supreme Court decision Conn v. M&F Worldwide Corp., or MFW for short. MFW was decided in the context of a going private merger in which a corporation's controlling stockholder caused the minority stockholders to be cashed out. The MFW court held that in this context, both of the cleansing mechanisms, slightly modified, that I described earlier had to be present, along with all of their attendant conditions. Since that decision, and as summarized in last year's opinion by the Delaware Supreme Court in Match Group, the MFW framework, as it came to be called, has been applied to every conflicted transaction involving a controlling stockholder. SB 21 changed that. Now, a conflicted transaction involving a controlling stockholder will be subject to a safe harbor if it meets the conditions of either of the safe harbors I described earlier, not both, with the additional condition that the committee be authorized to negotiate or oversee the negotiation of the transaction or to reject it. The exception to that is for going private mergers involving a controlling stockholder, which will require both of those modified cleansing mechanisms to invoke the safe harbor. This begs the question, what is a controlling stockholder? It's a very important question because controlling stockholders owe fiduciary duties to the other stockholders to which they wouldn't otherwise be subject in their capacity as such. Although one of SB 21's changes was to exculpate controlling stockholders from liability for the breach of the duty of care. Before SB 21, a controlling stockholder was either a stockholder who owned more than 50% of a corporation's voting power or one who exercised control over the business and affairs of a corporation. As Chancellor McCormick described in last year's Tornetta v. Musk decision, striking down Elon Musk's Tesla pay package, a controlling stockholder under that second prong did not need to exercise general control over a corporation's business and affairs, but could be one who controlled the particular transaction at issue, known as transaction-specific control. Despite only owning 21.9% of Tesla stock at the time of the transaction, the court found that Musk controlled the pay package negotiation and approval process and exercised transaction-specific control over Tesla, and in that context was a controlling stockholder. SB 21 changed the second prong of the controlling stockholder test too, by defining a controlling stockholder as one who either controls a majority of the corporation's voting power, or power to elect a majority of the board's voting power, or owns at least 1/3 of the corporation's voting power and has the power to exercise managerial authority over the business and affairs of the corporation. There is an important piece of context here that is required to appreciate the weight of this change. Last year, in a line of cases beginning with the Moelis decision, the Court of Chancery began striking down stockholders' agreements that granted broad governance rights to stockholders, such as pre-approval rights over major decisions by the corporation, which in the court's opinion infringed on the management authority that is delegated to corporate boards of directors by statute. In a similar frenzy of legislative controversy to SB 21, Delaware's legislature adopted Section 122.18 of the DGCL last summer, which permitted corporations to enter into contracts with current or prospective stockholders, which is another way of saying a person who is not a stockholder but may become one day, to take or not take any action as may be specified in the contract. Reading the two together, SB 21's minimum 1/3 ownership threshold for a stockholder to be deemed a controlling one thus means that a 32% stockholder with contractual pre-approval rights over any action a corporation may or may not take will no longer be deemed a controlling stockholder under Delaware law. I'll leave that point in the discussion of Section 144 there and move on briefly to the changes that SB 21 introduced to Section 220. These changes haven't made quite the same headlines as those made to 144, and for understandable reasons, but in a way I find them to be more significant because they affect a broader range of scenarios. Before SB 21, stockholders able to establish a proper purpose, including investigating wrongdoing or mismanagement, valuing their stock, or communicating with other stockholders, among others, were entitled to inspect such corporate books and records as were, quote, essential and sufficient to such proper purpose, which standard was meant to prevent Section 220 productions from being turned into full-blown discovery. In the Amerisource Bergen decision, Vice Chancellor Laster created a taxonomy of 3 categories of books and records to aid the court in analyzing the proper scope of an inspection, which categories included formal board materials, informal board materials, and officer-level materials. Formal board materials included those board-level documents that formally evidence the director's deliberations and decisions, and comprised the materials that the directors formally received and considered. Informal board materials were those evidencing the board's deliberations, information received, and decisions reached, all outside of formal channels, and could include emails or evidence from informal board gatherings. Officer-level materials encompassed communications and materials that were only shared among or reviewed by officers or employees. SB 21 dramatically changed that framework by amending Section 220 to include a comparatively narrow definition of books and records that included, among other things, the corporation's charter, bylaws, financial statements, stockholders' agreements, meeting minutes, records of board action, and materials provided to the board of directors in connection with actions taken by the board. These categories capture what were previously known as formal board materials, and perhaps some level of informal board materials, but not on their face informal communications, and certainly not officer level materials. Further, the books and records that a stockholder seeks to inspect must be specifically related to the stockholder's purpose rather than essential and sufficient. To inspect additional books and records beyond the defined category set forth in the statute, a stockholder must now make a showing of compelling need to inspect such specific records and demonstrate by clear and convincing evidence that such specific records are necessary and essential to further its proper purpose. To summarize all of this, if you view SB 21 favorably, you would appreciate that it provides tremendous clarity in understanding whether a given stockholder is a controlling one, and a roadmap for protecting interested parties from liability for conflicted transactions, requiring much less legal expertise and judgment than the prior regime. Not to mention that the board's attention is less likely to be diverted by stockholder demands for books and records. If you view SB 21 unfavorably, you might see it as a gift to directors, officers, and controlling stockholders who seek to wield corporate power to benefit their own self-interest, while simultaneously making it more difficult for concerned stockholders to investigate the corporation's operations, including but not limited to with respect to conflicted transactions. I'm not sure how I did on time there, but with that, happy to turn it over to my friend and former colleague, Kyle Lachmund.
I think you're right on time, Sean, and really appreciate you walking through it, SB 21, because it leads very, very nicely into what I was going to talk about today, which was a bit about how we got to SB 21 from my perspective as a Delaware practitioner. And I'm going to approach that discussion from an institutional advantage. And I'm going to do that because, in my view, Delaware corporate law has been and remains one of the best functioning institutions in the country. And what makes the Delaware corporate law institution so strong is that it is an ecosystem. And what I mean by that is that it contains multiple interacting but independently operating components that react and respond dynamically to one another. I think it's fair to say that the part of the ecosystem that gets the most attention, particularly from academics, is the Court of Chancery, and I think that's rightly so. The court, which I clerked on, is at the heart of Delaware corporate law, and the judges are exceptionally talented and hardworking public servants who cannot get enough thanks for the great work that they do. But as superlative as the Court of Chancery is, not to mention our excellent Delaware Supreme Court, the judicial branch is only one component of the Delaware corporate law ecosystem. There's the Delaware Secretary of State, which plays an important and underappreciated role in administering corporate filings. And there's the Delaware General Assembly, which maintains our corporate statute, the Delaware General Corporation Law, including by examining it on an annual basis and considering and enacting amendments to address economic, social, and legal developments. But the institution that I wanted to focus on a bit today, which is a little selfish because I'm a member of it, is the Delaware Corporate Bar. Some of the attendees here might be aware of the Corporation Law Council, which is a group of Delaware practitioners that assists the General Assembly in proposing and drafting amendments to the DGCL. But the role of the corporate bar extends beyond just the role of the council. The Delaware Corporate Bar serves as a feedback mechanism to the three branches of government. The Delaware Corporate Bar is small, call it a few hundred lawyers, and those lawyers who are only at a relatively small number of firms, they have relationships with all the major national law firms in the country that control an outsized number of the incorporation decisions. And because the Delaware Corporate Bar is so small, feedback from clients and then through the national firms gets filtered into a very small funnel. And that gives the corporate bar a good sense of whether there are issues in how Delaware corporate law is working in practice and whether those issues need to be addressed and the urgency of those issues. The bar can then raise those issues with the elected branches and with the judiciary. That feedback mechanism is really strong, and it's a huge reason why Delaware law has functioned as well as it has for decades. So that takes us to SB 21 and how we got there. So I moved back to Delaware in 2022. I had practiced in New York for a few years after clerking on the court, and then I came back. And since the time I came back, from my perspective, I would say there's been a near constant simmer of dissatisfaction in the corporate community with aspects of Delaware corporate law. Now, I want to be clear. I do not believe that this dissatisfaction, that the root cause of it was that our judges were doing a bad job with the law. I think our judges were doing a great job with the law, as they always do. In my view, the root of the dissatisfaction stemmed from broader social and economic changes that were creating flashpoints with Delaware law, mainly by increasing the incidence and expense of stockholder litigation. Delaware courts, more than most, are good at adjusting to changing circumstances. There's a famous quote from the Unicow case, which is one of the seminal Delaware takeover cases. And the quote is, quote, "Our corporate law is not static. It must grow and develop in response to, indeed, in anticipation of evolving concepts and needs." And it's just a fantastic encapsulation of what makes Delaware great. But the fact remains, though, that the judiciary and the Court of Chancery, those judges, they serve a common law role. And the common law is necessarily incremental. Judges are deciding cases based on the facts in front of them, and they're bounded by precedent in doing so. And that the judicial role can limit the ability of courts to respond quickly to changing circumstances. So sometimes the evolution in Delaware law comes from our courts, sometimes it comes from our legislature, sometimes it's both. So what were the broader macro developments that I think, from my perspective, were creating some tension between Delaware law and the marketplace in recent years? I think there are a lot you could point to, but there are two that loom very large in my mind. The first is the massive growth of private equity in our national economy, including venture-backed tech. And I think that's fundamentally changed how companies are capitalized, how they're owned, and how they're governed. And the second development, from my perspective as a practitioner, is the growth of an increasingly talented stockholder plaintiffs bar. There are so many great lawyers on the plaintiff side now that I admire. And I think it's more talented. There's more talent on that side than I think there ever has been. And that's led to more litigation. You combine great lawyering, tactical use of books and records demands, and a low pleading standard. You mix that all together, and what you end up with are a lot of cases that are getting past motions to dismiss. So there's dissatisfaction bubbling for a while. And then around a year or so ago, I think the temperature started rising. And that started rising when there were a few decisions out of the Court of Chancery that, whether they were right or wrong on the law, did not accord with market expectations. And then in the middle of that, you had the decision on Elon Musk's compensation. And I'm not going to talk about that case because my firm's involved in it and it's on appeal. But I think it's safe to say that was a very high-profile case. And that increased the temperature further. And so we get into last year, and all of a sudden, incorporating out of Delaware is a subject of public discussion. Deficit is coined. And the point I want to emphasize to people here is that for all the public discussions that are happening on this subject, there are lots more that are happening privately. GCs, CEOs, even directors are asking their lawyers, why are we still in Delaware? And it's in the public, it's in the air at this point. And that's where the feedback mechanism kicks in through the corporate bar. These conversations filter back locally into Delaware. And over the course of last year, people at my firm and other firms are getting a constant flow of information indicating that companies are unhappy. Near the end of the year, this concern and the temperature really rises further because there's now feedback suggesting that going into proxy season, there are a number of companies that are considering going to their stockholders about leaving Delaware. And again, there's been public reporting about some high-profile companies that were considering that. Again, for all the public reporting, there's a lot more of those discussions that are happening privately. And a lot of companies leaving, that's a crisis for Delaware. Our state budget depends heavily on franchise fees. 1 million people in the state, rely on that. And the feedback mechanism reached a point where it became apparent to not just the members of the bar, but also to the governor and members of the legislature who are getting that same feedback that corrective action was needed, and it was needed quickly to stave off the potential crisis. And then that is what leads to SB 21. And a number of the critics of the law have argued that its passage reflects an institutional deterioration of the Delaware corporate franchise. And I have the exact opposite perspective. I think the law shows the Delaware corporate ecosystem operating like it's supposed to. Feedback from our corporate constituents reach the bar and the elected branches. And based on the feedback, Delaware corporate law has adjusted. And that's not a repudiation of the judiciary or of specific judges, as some have argued. It is parts of the ecosystem responding dynamically to a changing landscape in a way that courts cannot always do. And that dynamic response is part of what has given Delaware law the responsiveness and sophistication that has allowed it to thrive for decades. And I also strongly disagree with the claim that's been made by some that the law is going to be the death knell or the end of stockholder litigation in Delaware, an oft-repeated claim made in the past about other changes in the law, and I think it's going to be proven false again here. And the reason I think it's going to be proven false is that all the parts of this dynamic ecosystem are going to adjust following SB 21. Plaintiffs' lawyers will adjust, the court will adjust, corporations will adjust. There'll be give and take inside that ecosystem, and things are going to settle down into a new normal. And that's why ultimately I'm optimistic on the long-term prospects for Delaware corporate law. The multi-part, dynamic, institutional strength that has allowed Delaware corporate law to thrive for decades, I think is going to continue to endure. So I'll close with that.
Thank you, Kyle. Ann?
Okay, so I'm going to start by talking about how we got here also and where we're going. And I don't think my backstory here is terribly different from Kyle's, except maybe I'll put an emphasis on different syllables. Okay, so obviously we can begin by saying there was a perception among some corporate boards that Delaware made it too easy for shareholders to sue, especially when a transaction involved a conflict of interest, and especially when that conflict was with a controlling shareholder. So one version of the story is Delaware courts were imposing unnecessary and unrealistic procedural hoops for boards to jump through in order to sanitize these conflicted deals. And another version is that Delaware was protecting shareholders from seeing their wealth expropriated by fiduciaries. Whichever version of the story you believe, corporate managers felt courts made it too easy for shareholders to sue. By contrast, Nevada has made it very difficult for shareholders to sue, and Texas just amended its law to make it more difficult for shareholders to sue. So both jurisdictions were competing for charters. Faced with this competitive threat, Delaware made some fairly dramatic amendments to its law that make it nearly impossible for shareholders to sue. And I know Kyle thinks, and a lot have argued, no, it won't really kill shareholder. I think it's going to kill shareholder fiduciary litigation, but we'll have to see. Also, it's worth mentioning, Sean said last year, Delaware made another very dramatic change to its law. It amended its law to make it easier for corporations to form contracts with individuals that would give those individuals governance rights, even if they aren't formally on the board and regardless of their voting power. Under prior Delaware law, boards had a nearly inalienable right to manage the company. Boards couldn't contract to just give away their governance power. Any limits on board authority could only be contained in the charter, and they could only be given to others if they held shares that gave them special powers. Delaware last year amended its law to say, no, corporations can just contract with individuals to let them exert control over board functioning. So where did all this come from? In my view, everything starts with the federal securities laws. Over the past few decades, the securities laws have been relaxed in a way that have made it far easier for companies to raise enormous amounts of capital privately. It used to be if you wanted to raise billions of dollars from investors, the only way to do it was to go public. Now you can do that privately. The upshot is we got startup culture and we got private equity culture, large firms that stayed private for prolonged periods of time. And these companies mostly didn't have to worry about shareholder lawsuits, so they developed their own norms and standards for corporate governance that didn't really mesh with Delaware standards. They increasingly allocated control rights through contracts, shareholder agreements, and they also developed a practice of using tight networks of repeat investors on their board, repeat players on their board. Silicon Valley is kind of known for these tight professional networks. And then these companies went public, and now they had public shareholders who could sue, and they smacked into the law that Delaware had been developing. First, Delaware started building out greater scrutiny of director independence. It started taking long-standing friendships and business relationships into account when considering whether directors were independent of each other. And that hit Silicon Valley firms hard because it meant a lot of their directors couldn't approve conflicted deals and therefore insulate those deals from judicial review because Silicon Valley likes to use the same people over and over again. Second, Delaware had decades of precedent saying you couldn't use personal contracts to allocate control rights, so that hit at both private equity and venture capital. And third, there was this issue of controlling shareholders, and there's a complex history here, but I'll just say Delaware has long been suspicious of conflicts, especially when a controlling shareholder is involved. It's always applied special scrutiny to those deals, which meant plaintiffs who bring lawsuits have a lot of incentives to find controlling shareholders everywhere. And because all of these firms that came out of Silicon Valley and private equity tended to have idiosyncratic control relationships, often through really bespoke rights and contracts and share classes, maybe they exert control through close relationships with other directors, it wasn't always clear when someone was or wasn't a controlling shareholder, and that created a lot of confusion. So especially when you throw in the uncertainty about who counts as independent, these developments work together to create what corporate managers felt was a lot of burden and a lot of uncertainty about how conflicted transactions would be viewed by Delaware courts. And Delaware amended its laws in response. But there's another piece of all of this, which I think is important. I think what also really matters here is the federal government. Because the reality has always been that Delaware standards, when they're perceived as too lax, the federal securities laws step in. Like the federal securities laws have gradually put new requirements for board independence, new requirements for board committees, new board responsibilities, that kind of thing. But right now, we all know that the federal government is not going to impose stricter standards. And I think that's really influenced what companies think they can get away with. So the takeaway here that I think all of this has made visible is how much Delaware's entire legal infrastructure was backstopped by this implicit threat from the federal government. And once that threat disappears, suddenly we have a full-on race to see which states can loosen standards the fastest. It blows away a kind of prior myth that the protections that Delaware offered to investors were demanded by investors as a condition of providing capital. So that's how I see where we are. And I have a couple of additional points about where I think we'll go. So Michal is going to talk about what Nevada's law does. I won't summarize the details of Texas's law. I'll just say that it's moved a lot closer to Nevada. And it also allows companies to amend their bylaws to require that any plaintiff suing derivatively has to hold 3% of the shares. That's huge. That's billions of dollars. As a practical matter, Texas is eliminating shareholder fiduciary litigation. But then so Nevada did that long ago. And to a large extent, I think that's what Delaware's done. That said, if businesses do decide to leave Delaware, as between Texas and Nevada, and I know there are people from Texas on this call, and you're not going to like my view, but my tentative prediction is that Nevada is going to win this fight. And I think that's because Texas is too political. I think Texas is in a posture where it's just implicitly been threatening that boards will get themselves into trouble if they engage in woke behavior or ESG. And I can give multiple examples. So multiple times now, members of the Texas legislature have proposed to let shareholders sue over ESG conduct by boards. Those haven't become law, but the threat's there. And what is ESG for the purpose of these laws? I don't know. No one else does either. Ken Paxton, the Texas AG, recently sued a Texas chartered nonprofit to get it dissolved because it was helping immigrants. Now imagine a company incorporated in Texas that Paxton thinks has engaged in ESG. Well, he sued to dissolve its charter? I don't know. American Airlines, it's not incorporated in Texas, but it's headquartered there, which means it can be sued there. And a Texas federal court just held that it violated its fiduciary duties by including BlackRock funds in its 401k plan. Ordinary BlackRock funds, because BlackRock has advocated for measures to protect against climate change. Right now, I'm watching a bill working its way through the Texas legislature that's to try to regulate proxy advisors who make recommendations based on ESG criteria. Again, without any definition of what ESG means. Now, to be fair, company boards tend not to like proxy advisors, so they might like that Texas is trying to limit them. But I think all of this just creates an environment where a Texas board is going to feel like it's at legal risk if it acknowledges climate change or markets to gay people. Delaware, by contrast, a shareholder sued Disney, seeking to investigate the company's decision to publicly object to Florida's Don't Say Gay law, and that case was thrown out. I'm just less confident that would happen in Texas. So it seems to me that Texas is going to have to make a choice. Does it want to be a hub for business incorporation, or does it want to fight the culture wars? It's going to have to make up its mind. But I'll finish with this, and then I'll stop talking. Texas is also making some other interesting moves. It's been gearing up to challenge the internal affairs doctrine, which is the doctrine that says that where you're incorporated dictates your law. It is now trying to apply its corporate governance laws to companies that are not incorporated in Texas based on whether they have headquarters in Texas. This is a much bigger deal to Delaware because if Texas gets to apply its law just based on whether companies are headquartered there, then it doesn't matter where you incorporate. And that means Delaware doesn't matter because nobody's setting up headquarters in Delaware. And when you throw in that Delaware has moved so much corporate governance into these personal contracts, well, those contracts, contractual governance arrangements, they're not governed by Delaware law necessarily either. They can be governed by any law. So I think the real shakeup that we may see is a question of which law applies in the first place. And that's when I'll stop talking.
Thank you, Anne. Michal?
Great. Thank you all for these great points. So I also like to start by taking a step back and trying to answer the question, why now? What happened? Why it's so wild? And I think that another aspect, and I think everyone raised really good points about it. I'll just add that another aspect is that It happened in the past that Delaware has been criticized and suffered some backlash. So a significant one was in the mid-80s after Interco, that Chancellor Allen decided Interco, which limited the use of the poison pill. And back then, Marty Lipton distributed a memo, maybe it's time to leave Delaware, if you guys remember. And Delaware response was with the Paramount decision, which really many interpreted as providing managers with the power almost to just say no. So a lot of deference to using the poison pill, and many also interpreted that as really matching the UNICO standard with the protection that was provided by other states. So that the Paramount case, by allowing managers to just say no, provided this similar protection to the anti-takeover rules that were emerging in the other states. Okay. However, aside from the anti-takeover rules, the corporate law of other states was very similar to Delaware, including Nevada. So, put differently, the last time Delaware faces a significant backlash for reasons that different reasons, development of the law, development of the business world, changes, common law, adjusting, and so forth, the competitive landscape was such that other states were similar to Delaware corporate law. And where there was a difference, which was in anti-takeover law, Delaware matched its law to the law of other states, okay? Since the 85, Nevada has started to deviate. Nevada passed its exculpation statute in 87, and that created like the first deviation. And then Nevada continued and continued and continued, and to 2017, it really codified the internal affair doctrine, because some of the, not all of the courts were kind of distinguishing enough Nevada from Delaware. And there's a really nice paper about it now by George and Siegels and others that find that had a negative effect on monitoring and value. So, but now it's the first time that Delaware is experience a significant backlash because of private equity, because there are more controlling shareholders, and so forth and so forth. And there are other states that actually offer a very different benchmark. And I think this is part of the instability of the current situation. It is new. It's not a coincidence that we are, what we are viewing seems like a more fragile equilibrium. It's a new situation where there is a combination that hasn't happened before, for backlash on the one hand, and one state that offers a really low benchmark. And if I discuss more of this point in my article, Nevada versus Delaware, so you can see it there. But because of that, I think it's also important to understand where exactly Nevada law stands. And I think here there is still a lot of confusion, and there were some comments and opinions, for companies that reincorporate, and from Nevada Secretary of State. But my reading of Nevada law is different, and I'll just say shortly why. Nevada provides very significant, and again, I describe it in more details in my article, but Nevada provides very significant bars from litigation. SB 21 is still very far from Nevada law. And because of that, I'm not sure that SB 21 is going to be the end of story. I'm not saying this is from a normative view. I'm not saying whether it's good or bad. I'm just saying we haven't seen, we might haven't seen anything yet. And I'll say why. Nevada exculpation statute exculpate directors from everything except for intentional misconduct, fraud, or knowing violation of law. Theoretically, Nevada courts maybe could have still interpreted it as suggested by Nevada Secretary of State as more in line with fiduciary duties and so forth. This hasn't been the case. And also that hasn't been the Nevada legislative intent, because they passed in 2017 a law that says we should interpret it differently. So the way it's interpreted is that you can be liable only if the plaintiff shareholders manage to bring facts, particular facts, that show intentional misconduct, fraud, or knowing violation of law. And Nevada courts interpreted it as facts that also show the intention and the knowledge. So if you want to show knowing violation of law, you also have to bring facts that show the directors or the officer knew what the law was, so that there was some actual discussion that this is the law and we're going to breach it. It's very difficult to get this. No other states requires that. Similarly, to show intentional misconduct, you have to show intention of wrongfulness. So even in very extreme circumstances where it was clear that the actions were wrong and the self-dealing was extreme, and directors completely relinquished those duties, still the Nevada courts decided that there was no particular facts that show that there was intention for wrongfulness. And Delaware law still also never required intention in order to apply entire fairness to self-dealing. It's the conflict of interest, the trigger of entire fairness is a result of the structure of the transaction, not of the intention. So these intentions are very difficult to find even in minutes. Yet, on top of that, okay, if it's not enough, on top of that, and there's a lot of confusion about that too, because many times the firms that reincorporate to Nevada, they just put all of the section about shareholder inspection rights in their proxy materials. But this section is long and confusing. The bottom line of this section is that in private companies, shareholders in Nevada sometimes, under some conditions, will have some inspection rights. In publicly traded companies that file reports with the SEC, shareholders have no inspection rights. So no access to books and records. So the Delaware amendment to inspection rights indeed somewhat limit, the broad inspection rights that develop to be like include emails and so forth, but it's very far from in Nevada. In Nevada, there's no access to the minutes, to the board minutes, no access to any material that is not filed with the SEC. And with this limited access, you're supposed to bring these facts that show intent or knowledge. So it's really impossible. Now, and this is why we see no lawsuits and the ones we have are dismissed. Finally, people like to point to the Wynn Resort case that was dismissed, and again I explained it in the paper, that was dismissed, and the Nevada Secretary of State and also opinions about reincorporation to Nevada refer to that. However, that was not dismissed. The Wynn Resort case, which dealt with the sexual harassments, systematic aggravating sexual harassment by Steve Wynn. The reason why it was not dismissed is actually a very unique, it's an outlier. Why? The only reason the plaintiff shareholders managed to pass these high requirements of showing knowledge, not only of your acts, but also showing knowledge, particularized facts for knowledge that you knew what the law is, was because there was a public fight between Steve Wynn and Elaine Wynn, his former wife, who was also a shareholder in Wynn Resorts and was on the board. And in these public fights, there was lots of public accusations. And the board responded to these accusations in the press. And in one of the responses in the press, the board said, of course, if we knew about this harassment, we would have reported it to the gambling authorities and the SEC authorities, okay? And then also there were later other facts that showed that the board knew about the harassment. But the fact that the board responded in the press like this, the judge is including it in the case and says this is an indication that the board knew that there is a legal requirement to report this sexual harassments. And, we all know that the board should have known it, but this is not enough under Nevada law. So the judge really included this part from the press release as a particularized fact that the plaintiff shareholder brought that support the fact that they knew that there is a law that requires them to do so. So this is really an outlier case in the sense that everything was out there in the newspapers because of this public fight. And for that reason, the plaintiff shareholders managed to meet this high burden of bringing particularized facts that show real knowledge of the law, not only of my acts as a director and officer, so, of the officer acts. So Win Resort is really not an example for a case that could be that there are cases that sometimes are not dismissed under Nevada law. It was because of these very particular circumstances. In cases when there is a public fight and everything is in the press, and maybe the directors are talking to the press, and saying everything to the press, then maybe it's possible to succeed in the motion to dismiss stage. But other than that, with a high burden of no inspection rights and the high burden in the motion to dismiss stage, it's really close to impossible. On top of that, Nevada has explicitly replaced Unical and Revlon with the business judgment rule, and that's unrelated to whether I can count under constituencies or not. Business judgment rule, use of poison pills, staggered board, selling the company, no Unical, no Revlon, business judgment rule. And finally, this week, Nevada has just passed another amendment with respect to following to SB 21, maybe as a response to SB 21 with respect to controlling shareholders' duties. And with this amendment, as far as I understand it, it really applies the exculpation statute also to controlling shareholders. So that from now on, controlling shareholders also will be liable only if there is intentional misconduct, fraud, or knowing violation of law. It's not enough to show just, self-dealing that is not fair and so forth. So I think, this is ongoing, and it's important to understand we are experience something for the first time. It hasn't been like this before. We've never been in this situation. So while we discuss what's happening now, we have to keep looking forward and try, to predict, because it might not be the end of story. And I have to say, I'm concerned about how fragile this equilibrium is. And I think it's going to be hard to keep high standards. I think that one question maybe is, how did Delaware manage to keep such high standards for such a long time? We see from a lot of things that are happening in the world, that it's difficult sometimes to keep the high standards. And I think, we are in a still fragile equilibrium.
Thank you so much, Michal. I'm going to give all panelists the opportunity to respond, to comment on co-panelists' remarks. And at the same time, I want to remind that you can use the Q&A function to submit questions for the panel. So I'm going to let Kyle, Sean, and Michal, if you have any comment, response, reaction to your co-panelists, feel free to unmute yourself, and then we can move on to the Q&A.
I'll just jump in just to supplement, because about Michal, just talking about Nevada, I didn't get into the specifics of what Texas is doing, but when I said it's moving a lot closer to Nevada, it very much is. So its law now says that any fiduciary litigation, the plaintiff has to show fraud, intentional misconduct, an ultra-virus act, or a knowing violation of law. So it's a lot closer to Nevada standard. What's great about that is Texas law says even an action brought in the corporation's name has that standard. And what I mean by that is it's not just shareholder or derivative actions. It would mean if a board member chose to sue, a board member itself chose to sue, it would still have to decide that it show that there was intentional misconduct, ultra-virus act, or knowing violation of the law, or fraud. Additionally, like Nevada, they're limiting inspection rights. They didn't say in a public company, no emails, no texts, but also specifically that you don't get books and records if you are investigating to sue for the purposes of suing in a public company. So one way or another, they're using a lot of words to get to the same place in both cases.
They did research on Nevada law. Great. I'd like to ask Kyle. I thought it was really interesting for me to hear, like, the I'm sorry? Can I?
Oh, sorry, you lagged out, so I didn't want to speak. Please go ahead.
Oh, sure. I'm saying it was very interesting for me to hear Kyle describing, like, from his point of view, the development of the history, the recent history of how things happened. I think both for Kyle and for Anne, I'd like to ask also, how do you think also the rise of firms with large shareholders? So Anne discussed private equity, and I think private equity and definitely contributed a lot to that. But how also the rise of firms with large shareholders, also contributed to maybe the rising uncertainty, the needed some adjustment in common law and so forth.
Yeah, I mean, I think that they're related, right, to the growth of kind of private equity, and founder-backed companies, because I think you have a lot more companies with large minority stockholders, and that really laid bare some uncertainty in Delaware law of who is a controlling stockholder. And if you're a transaction planner and you're trying to figure out when you're doing a transaction in advance whether the person you're dealing with is a controller, Delaware law didn't really give you a clear answer, and that was difficult, I think, for people to deal with. And you had the MFW route, but that wasn't really practical for a lot of types of transactions. And so I think that's why after Match came out last year, that confirmed that the sort of double trigger requirement, so to speak, applied more broadly. I think there was more pressure to push that back, because you had a lot of companies that then didn't know how they were going to deal with those kind of transactions.
And I'll just sort of jump in to note that there certainly was pressure, I think, created by those set of circumstances. And but in the past, when the Delaware jurisprudence has sort of moved in a direction that people weren't expecting, or there were complaints about the ways that things were going, it was less so that the Delaware legislature would step in the way that it has with SB 21 and with Section 122.18. When I first started, I remember in sort of the 2010s when appraisal litigation was going crazy, and I was working with folks in the defense bar who would sort of talk about it's so difficult with appraisal litigation because there's no off ramp, right? And no matter what happens, you're going to get to discovery, you're going to have to go to trial, and those cases are long and complicated and very expensive. And but then in sort of 2018, 2019, with a series of cases, DFC and Jardin and a number of others, the Delaware judiciary responded and set a sort of not quite de facto deal price, deference, but that's ultimately, I think, the result of it. Now we see much less appraisal litigation in Delaware, and so I think that what's been concerning for some is the process by which these changes are being made in a sort of a top-down manner without relying on the expertise of the Delaware courts.
Yeah, I'm sorry, I just have to jump in on that because I know Kyle framed this as the different pieces of Delaware law and so forth, but I mean, I think most observers would say that this was a dramatic change from how Delaware does it. Like, you can go back literally decades, and what you find are articles that are written mostly by Delaware judges and by academics talking about what makes Delaware special. And what they're writing is that it's case law based, that this is a common law system, that all of these standards are developed through common law. And that's just article after article after article. Yes, the legislature steps in and it tweaks things, but mostly it's a common law system. And there are also articles that say, and yes, sometimes that'll be slow and it won't quite catch up, but it's still better to do things on a case-by-case basis. So what the changes mean is not just what they do substantively, although I think that's pretty dramatic. It represents a completely different approach to lawmaking that is very different from what historically Delaware sold itself as being special about.
Yeah, and I disagree with that, or I disagree that is sort of the broader takeaway here. I mean, one, I sort of disagree empirically that this has always been kind of court-based movement to changes in the law. I mean, you had 102B7 back in the 80s and 203, and then more recently, I mean, the form selection bylaw piece when you had the sue on every deal era, like you had both a a judicial response and a legislative response to that. So I think the legislature plays a role. And my perspective as a practitioner is sort of post these amendments, we are still in a very common law based system where judicial discretion and case by case adjudication and what the chancellors do really good, which is looking at a particular case and sort of sniffing out whether there's something wrong. I think that system is still going to endure and be very strong. It's just the landscape of how that operates. It might be litigated a little bit differently, right? So I think you're going to probably see litigated a little bit more about whether, boards were aware of, material facts surrounding, somebody's relationship and, gross negligence, the duty of care. Maybe it's due for a comeback here, the duty of care. Like, I just think the system is going to respond dynamically. And I think that system is still going to include the Court of Chancery very much playing a leading role.
And I agree with that, but I agree with parts of that, but I'll also note that with the changes to Section 220, for example, we've got a long list of Delaware cases where the courts have sort of encouraged stockholder plaintiffs to take advantage of the quote tools at hand when deciding whether to pursue plenary litigation, and I'm thinking very carefully about that sort of line of cases because I'm wondering if the Delaware judiciary will be still so inclined to sort of encourage or rather discourage stockholder plaintiffs from filing plenary litigation without having taken advantage of Section 220, to the extent that Section 220 might now be sort of a duller tool to sort of continue the metaphor, and I wonder if this actually might potentially, and this is just something I'm thinking about. I don't know that I have an opinion one way or the other, but whether this is actually going to lead to more full-blown discovery in cases where the sort of the Section 220 route has been rendered unavailable or less useful.
Yeah, but I mean, there's still 220 still there. The documents that it specifies out at the default are more or less the formal books and records that the Supreme Court had said in the default case you're going to get. And there's still the escape valve of the exceptional case of getting more documents there. It's just the line's been moved somewhat, right? It's a higher standard now. So it's a marginal move, I agree. But it's not just like wiping out 220. It's still there, and I think you'll still have cases where stockholders, if they can meet the heightened showing, will be able to to go beyond that. It's just going to be incrementally more difficult than it was in the prior regime.
Well, and then we're going to learn a lot more about what clear and convincing about what that standard actually.
Sure. Yeah, and that's where the judicial discretion is going to come in.
So we have a bunch of questions in the Q&A. So I'm going to start to pick them randomly. And I'm going to start, I think, Kyle, from your last point, it was very interesting to hear the interest group point. And there's a very specific question, is that has the legislator ever jumped in before a case even made it to the Supreme Court in the past? It's very specific, just thinking about the dynamics that we were discussing.
I mean, if you count Section 122.18 as being the legislature jumping in on the Moelis line of cases before that went to the Supreme Court, but that was last year. I assume that the person asking is thinking about maybe a little further in the past than sort of the more current moment.
Okay, another question going, I think, on presentation in general and the theme of race to the bottom. So this question touches a bit on the federal corporate law. So do you think federal preemption is the inevitable answer to the ongoing race to the bottom among Delaware, Nevada, and Texas in corporate law? While I recognize that such a shift is unlikely under the current Trump administration, a future Democratic administration may view the issue quite differently. I'd be curious to hear your thoughts on whether a federal framework could or should step in to address those dynamics. I think there's a lot of academic work on those aspects, and I let Michal or Anne or even Sean and Kyle to take on this general question about federal corporate law.
It's very difficult for me to predict because I feel like there's such upheaval with the federal system that I can't say that there is going to be a Democratic administration or what legal powers it might have if it exists. I mean, I think we're entering into such uncharted territory from a federal law perspective. But I think that, should we have a Democratic administration, then it's just going to take, well, already, I mean, we've seen what Democratic SECs do. They impose many more disclosure requirements. They impose substantive governance requirements on firms, especially private equity funds. They tried to do that. It was struck down by the Fifth Circuit. We've seen they have disclosure requirements that aren't disclosure requirements. They're governance requirements. I mean, like when you have a disclosure requirement that says, describe how the board takes this risk into account when making decision making, that's not a disclosure requirement. That's a governance requirement. So that's what we've seen Democratic SECs do. So that's what I would assume we would see if we had, you know, Democrats in power, and it would be hastened along by your first big corporate scandal. So I think that is one piece of the inevitability, but the other piece is moving away from the internal affairs doctrine at all. As I said, Texas is already like starting to challenge it by trying to apply its corporate law to companies that are just headquartered there. And the fact that Delaware is now given so much authorization to put corporate governance in private contracts, I mean, we're really in uncharted territory about whether the place of incorporation is going to matter in 20 years.
So I think that if we end up with a system that is closer to Nevada and Texas right now, then this law actually is going to be very different from the law also in many other countries. So Nevada is now selling itself as like a codified corporate law that provides more certainty versus the common law system of Delaware. Common law used to be considered as, you know, one of the main advantages of American corporate law, but the truth is that it's not only codified corporate law, because if we compare Nevada law to other countries where they have like civil law, corporate law, these countries have other requirements. For example, in countries with civil corporate law, for self-dealing transactions, there is a requirement of approval of majority of minority. As far as I know, in the majority of these countries, there is such a requirement. Approval by majority of minority of the shareholders. It's a codified requirement. So if we look from these lenses at Nevada corporate law, then it's a codified law that really provides almost, you know, complete bars from liability. And in that sense, it's a lower benchmark, much lower also than other countries. So I think that, you know, and it's also, it bars also lawsuits for self-dealing, for conflict of interest, for not for subject that we have seen, you know, meritless lawsuits or futile litigation. These are not the subject where we have evidence of excessive litigation. So I think that if we end up that low, you know, we might benefit from some limitations or intervention. Of course, you know, we have to consider also the potential costs of federal regulation, which I completely agree that there are, and I completely agree with Anne that it's very difficult to predict how they are going to be.
A question for you, Michal, and the other countries that you're contrasting, like what Nevada standard is with. I mean, how many of those countries really have like systems of private enforcement, like the way that the U.S. does with sort of stockholder litigation?
Yeah. So, for example, in Israel, there is private enforcement, and the law is codified. And for self-dealing transactions, there is more codified. There is a codified requirement to have a majority of minority approval. And from what I understand, this is also the case in many European countries with civil law systems.
A very quick question. Assuming that, you know, I assume the SB 21 changes can be overridden by a corporation article of incorporation or bylaws. If that's correct, so first part of the question, do you think the institutional investors are going to insist on overriding some of the new language in SB 21? Do you have any prediction? And can you give us the status quo of the law on this aspect?
I mean, I'll tell you my prediction, which is that I think it could be overridden. I don't expect institutional investors to insist on those overrides. Would be my guess. I don't really know, or it's not been clear to me that capital, broadly conceived, stockholders as a whole value incremental litigation rights all that highly. At least that's always something I've wondered. I know like there's parts of institutional capital that have indicated they do, but it's never been clear to me that more broadly they do. And I think that's because, and again, I think this is a broadly debated issue in the literature. I know one of interest to Professor Lipton, I think, that she's commented on is the value enhancing quality of stockholder litigation, I think, is very disputed in the literature or unclear. And so I guess I'd be very curious for her thoughts on that question and anybody else's.
Yeah, I don't expect to see I don't expect them to see much pushback. I mean, one of the things that shocked me is how little pushback we saw from the investor community just when these were being contemplated.
Yeah.
There were some investors who objected to SB 21, but I still would consider it relatively muted. There has been, we'll allocate capital elsewhere, but there isn't an elsewhere to allocate it to. But really, and I think this is, kind of how we got where we are. Institutional investors have been giving up an extraordinary number of rights and investing in private equity and private capital. And, they might, I don't know whether they're giving up litigation rights. They might very well be giving up arbitration rights. They are giving them, I think, as a practical matter, because if you sue your private equity firm, you're not going to get more deals. So one way or another, institutional investors have sort of demonstrated with their feet that they're willing to accept an extraordinary loss of voting power and governance rights, an extraordinary loss of information rights to have access to various investment opportunities. And I think that is part of what led to, I think a private equity in Silicon Valley, BC push. Well, gosh, investors are perfectly fine investing in companies in which they have no voice. That what they care about is the dollar sign at the end. And therefore, we can do this in public companies. And I think that's where a lot of this comes from.
I think it's, it might be a little too early to say in sort of the history of private capital. I mean, certainly, I think that if you're talking about the sort of top 6 fund managers that seem to have control over 60 to 70% of the sort of private equity of private capital, I think that you're unlikely to see these kind of pushes in their sort of underlying investors. But certainly in the middle market, which is where a lot of my private equity practice is, there are sort of increasing sort of demands for governance, for governance rights, for reporting rights, and it is true that there's probably always going to be less litigation in private equity than there is in with corporations. It's just sort of the nature of how those relationships develop. But I think that as the lifespan and the history of private equity sort of extends, we're going to see more and more of sort of those types of litigation because investors are getting smarter and with the sort of and the structure of fund to funds and how all these private equity firms are sort of investing in sort of each other's strategies. I think that there's a lot of movement there, but it's also important to note that that's not necessarily going to be a corporate question. I mean, I spend very little time dealing with corporations in my day to day. I work on limited partnerships. I work on limited liability companies and the various forms thereof. And that's where I'm seeing a lot of sort of creativity both with respect to governance and otherwise.
I'll say that interestingly, there is the index fund seems to play a role in the reincorporation decisions. So if you guys remember, TripAdvisor, for example, had the support from the controlling shareholder, but other than that, only 5% of the other shareholders voted in favor of their incorporation, which suggests that the large institutions did not support, at least some of them did not support the reincorporation, which if I remember correctly, they did not. And in general, I think that was an impediment, that is still maybe an impediment to reincorporation to Nevada. Most of the companies that recently reincorporated had these reincorporations were supported by votes from the large shareholders, because it's difficult to get institutions to vote in favor. And maybe, because they have to make the decision whether to vote or not. As it's not the same as being actively, objecting SB 21. But another indication of that is that a recent reincorporation by Fidelity, not the big Fidelity, another it's a company that tried to reincorporate last year and didn't get the support of the shareholders. And now they reincorporated, and the proxy material said that they got to agreement with their shareholders, with some of the shareholders, that they will include in their charter the Delaware exculpation statute. And that's also consistent with the voting guidelines of the index funds. So, for example, if you go to BlackRock voting guidelines with respect to voting on reincorporation decision, it says take into account the differences between the state's law and protection for shareholders in deciding whether to support or vote against the reincorporation. So I think the institutions still play a role. Sometimes they are an impediment to reincorporation to Nevada. I think to Texas, it used to be less difficult because the law was more similar. So if you take into account this guidance, voting guidelines, then, but this is changing too. On the other hand, I'll just say, and this is also something, because of this, a change like SB 21 actually, makes the difference between Delaware law and other states maybe smaller, and this could maybe convince the institution to be more flexible with voting for reincorporation, because again, their voting guidelines are saying take into account the differences in the law of the states. So in that sense, changing the law to get closer to other states, on the one hand, maybe decreases the motivation of some firms to leave, but on the other hand, it maybe facilitates reincorporations by making it less difficult for the institutions to vote in favor of the reincorporation, along with in a way that is aligned with their voting guidelines.
Perfect. So I'm going to blend two questions together, and I think both questions touch on the role of business courts. So one question was precisely directly to Texas and the fact that Texas Business Court do not have precedent. How do you think this is going to affect the company's analysis to decide whether or not to reincorporate into Texas? And the other question is that how do you think the creation of the Texas Business Court and the proposed court in Nevada affect Delaware status as a two-go state? So again, what is the role of the judiciary? How do you think the role of a specialized judiciary in this new state might support this Dexit race?
Well, I can start by saying there was an interesting discussion at the Berkeley Spring Conference a couple of months ago with one of the judges on the new Texas Business Court and a Nevada Supreme Court justice and one of my partners talking about the various aspects of the three states' laws. And I thought one of the interesting things about that was, the Nevada and Texas courts talking about how much they were, trying to emulate Delaware in making these new business courts. But it takes time, I think, is my reaction. And so sitting here in Delaware, I feel good from an institutional perspective about the relative competitive advantage from our long-established Court of Chancery versus a newly established business court. Now that advantage can be eroded, but I do think it will take time to build up kind of the institutional bones of the new courts.
And that's without mentioning, sort of the role of juries and the lack thereof in the Delaware Court of Chancery that I think, should rightly make, potentially some corporations nervous, particularly the ones that might not be politically popular for whatever reason at whatever time. Whereas, there's I don't know, maybe because of my chancery history, I'm just sort of biased in favor of specialist judges in this way. But I feel like, I've always felt that, juries could be a bit more of a gamble.
I mean, Michal, you're on top of the Nevada stuff.
Yes.
I thought
I'll say the following. I think I'm so high on Delaware courts and Delaware judges. I think their expertise is immense. I always like to show my students hearings from Delaware courts just that they understand the level of the discussion and the depth, and I think they are doing an amazing job. And I think that the courts also, their efficiency, the expediency, It's unbeatable, and it's so important that the fact that these takeover cases, last 3 weeks. It's really unbelievable. I think the quality of the work that is being done in Delaware is going to be very difficult to match. Having said that, and again, I'm not talking from a normative perspective. I'm just again explaining what is the reality and where we are, and why I'm actually concerned about what's going to happen. What Nevada did and Texas is now doing by adopting this very limited intentional misconduct fraud or knowing violation of law, they're really trying to erode the importance of the expertise of the judges, because in order to apply intentional misconduct fraud or knowing violation of law, you don't need expertise in. It's not fiduciary duties. These are a concept from other fields of the law, and it's very narrow. There's very little discretion. So their codified law, they cannot match the expertise of Delaware courts. But the debate here, or the competition here, is really it's a collision between a different question, which is it better to have a corporate law that is common law, which was our pride, and there's also some evidence, the LLSV studies, common law versus civil law, that this is a good system, and we've seen how the positive sides of the common law. Can we replace it with just really Nevada and Texas are not offering expertise of the judges. They're offering codified corporate law. Now, in Nevada amendment that passed this week, they also give corporations the option to waive jury trial. So the jury trial, which was of significant disadvantage, they're now giving corporations the option to opt out of it. So I think that's another, competitive advantage for Nevada. And the problem is that even if Delaware law is much better and the common law is much better than having a codified law with no liability, which also Texas is going in this direction. And again, I said no other countries really offer this no liability codified law. There are insiders might prefer that, and they're making these claims now. Many of the proxy materials are now saying we prefer to go to Nevada because of the certainty of its codified law relative to the uncertainty of the common law system. So it's now framed this way.
But I mean, what certainty means is we know we won't get sued. I mean, like it's sort of funny.
Exactly.
It's just funny to say that there's much importance to the courts. The whole point is to make it so that the court isn't doing anything. Now, there might be takeover disputes or whatever, but like merger disputes, stuff like that, you can contract for any court you want. So I don't think the courts are going to matter if the whole point is to make sure that you cannot bring fiduciary claims.
Yeah,
there's a lot of certainty. You're not going to be sued. You cannot sue. That's really the certainty. But it's not. But of course, the motives to go there. It's not only because of the cost of uncertainty. It's because there are rents for the insiders, and it's a problem.
Yeah, I don't know if the dichotomy is that stark, right? I think there's always going to be parts of a statute, of a body of law, that people will be able to bring lawsuits on, and I mean, it's different if you're like cutting off standing in the way that Texas might be proposing to do with some derivative claims. But I think in a lot of these cases, I think you will still have stockholders being able to bring suits, and I think some of them will probably, even in those other jurisdictions, much as they might set the bar in a different place, would still advance to litigation. It might be incrementally less than what would happen here or somewhere else, but I think it would still advance. And then the relative expertise of the court, I think, does become an issue.
It's actually significantly less lawsuits and significantly less rates of non-dismissal, and there are also very little lawsuits because I talked to a plaintiff lawyer from one of the top, who was a guest speaker in my class, and he said we had one case in Nevada in the past, years ago. It was a disaster. We lost, and we don't want to sue there anymore. We don't want to waste our resources on suing companies in Nevada because you cannot succeed. So Wynn Resorts, before the sexual harassment case that were on the newspapers, had lots of troubles, tons of self-dealing transactions, of Steve Wynn and the company, which for sure would have been litigated in Delaware. But no one is suing because you can't pass this crazy thresholds.
I think it's, I know, it seems to me it's a small data set and, we're still.
Oh, I agree. I
seeing
agree.
Going to happen there.
And as much as we talk about Exit, like as everybody I think is well aware, obviously Delaware is still the big game in town when it comes to both reincorporations into the state, new public company registrations in the state, and it's really not even close yet. On the other hand, certainly every time a company does choose to reincorporate, it makes rounds on my LinkedIn feed. But I understand that to be a small subset of the actual numbers that we're talking about here.
I agree.
So unfortunately, we ran out of time. I have a super quick question, super quick, for connecting a bit to the role of securities regulation. What do you think is going to be the effect of the new stock exchange, the Texas new stock exchange, into this debate? Do you think, super quick, do you think we should keep a look what's going to happen with the stock exchange and the primary market and corporate laws? Any quick thought, and then we have to wrap up, unfortunately.
Well, right now, Texas, when it's trying to challenge the internal affairs doctrine, is also doing it with the stock exchange. Like it's saying our corporate governance law, as a matter of state law, applies to companies listed on the Texas Stock Exchange. But I don't know if they can do that. But that said, what certainly can happen is that the Texas Stock Exchange can have its own rules that the SEC approves. And under this SEC, I could imagine a world where corporate governance is moved into the exchanges by virtue of a very cooperative SEC. And that, again, it doesn't matter it doesn't matter where you're incorporated if you're subject to those preemptive rules.
Perfect. So Michal, Anne, Sean, Kyle, thank you so much for joining this panel. It was a fantastic way to end the week. Thank for all the attendees. Sorry if you couldn't go through all the questions. Please, continue to follow the LSE, the Program of Financial Markets. We're going to offer more webinar and more events. Thank you so much.